All rise. The Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Curie I. Mander, Chief Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral argument, the 5th District Court of Appeal. I've already been introduced, but let me introduce the other panel members. Seated to my right and your left is Judge Meredith Sasso, the newest member of our court. And seated to my left and your right is Judge Jim Craner, who is Associate Judge. He's a judge in Orange County. We're pleased to have him join with us today and assist us in our work. We have two cases scheduled for oral argument. Each side will have 20 minutes. The appellant is entitled to divide that time between an opening argument and a rebuttal argument after the opponent has spoken. If you tell me how much time for the appellant, if you tell me how much time you wish to reserve for rebuttal, when you first come up here, I'll try to help you in that regard. If you have any cell phones or other electronic devices, please make sure you turn them off, put them in silent mode so that the oral arguments will not be interrupted. Okay, we will go ahead and start with the case of Valerie Harrison versus Richard Harrison.
Judge, I'd ask for 5 minutes of time for rebuttal at the end.
You may
Please, the
proceed.
court. I am Brandon Tyson. I'm here this morning representing the appellant, Valerie Harrison, and we have 3 issues on appeal. The first issue was, in this case, the trial court imposed a geographic restriction on the wife following the trial with regards to time sharing with the minor child. Court heard the evidence, heard the testimony. Ultimately, at the end, the trial court determined that the child would reside primarily with mom and provided dad with a decent time sharing schedule. Basically, it amounted to every 2 weeks, the child would be with mom for 8 overnights and the child would be with dad for 6 overnights. What the court did was it conditioned the continuation of that schedule on the mother relocating back to Brevard County.
Let me ask you this. It seems to me that the trial judge believed it was in the best interest of the child first to have both parents in Brevard County with the mother having majority time sharing. The second best situation was that if the mother was in Orange County, then it was in the best interest of the child to be with the father having majority time sharing in Brevard, and that the third best thing was your client having majority time sharing in Orange County. Would that be a fair assessment of what the judge's priorities seem to be?
I think that's accurate to state, but the issue, though, is that the court, when hearing the evidence and hearing the testimony, it gets the facts it gets. So the evidence before the court was prior to dad filing his petition, the mom was already in College Park. She was in Orange County. And so while the court determined that, dad is entitled to a meaningful relationship with the child, that's really sort of the policy in the state of Florida sort of to begin with, absent, sort of different type of circumstances. So I think the court tried to kind of create the perfect situation perhaps it wanted the evidence and testimony to be. The reality was mom was in College Park. The evidence, in fact, showed that dad was aware of that. Dad facilitated the move. Dad actually helped purchase a house in College Park. It wasn't as if one of these cases where mom's like, hey, I want to just sort of position myself or jockey myself for purpose of litigation. She moved, and the specific reason that she moved was that the child was being homeschooled, and in addition to being homeschooled, he was in a program in Orlando, Tuesday and Thursday, I believe. And dad was aware of that. Dad had agreed to that. They had originally agreed to the homeschooling, and together they made a joint decision to buy a house in College Park, made a joint decision that mom and child would reside there to facilitate the child going to that school on Tuesday and Thursday. And then ultimately, like so many times it happens, the parties' relationship deteriorated, and mom decided she wanted to stay in College Park, was certainly her right to do so, and dad was in Indian Harbor Beach in Brevard County, where the former marital residence was. So those were the facts. Those were the findings of the court. And so, the case law says, and the statute says, that, the relocation law was not applicable when mom moved to College Park. And so now the relocation law does come into effect, obviously, once the filing, because the statute says 61.13001.
But under the statute, it says relocation means a change in the location of the principal residence of a parent or other person from his or her principal place of residence at the time of the last order establishing or modifying timesharing.
Or if there is no order, I think it says at the establishment of.
Or at the time of filing the pending action.
So at the time of filing,
To establish or modify timesharing.
Yeah, so when Dad filed, Mom was already in College Park. The evidence showed that. The trial court actually made that finding. So the principal residence of the child at the time of filing was College Park, was Orange County, as you said.
Didn't the mother also testify that she might not have an issue returning to Brevard County, though?
I think the question during the trial was the judge, and I can't remember if the judge or counsel for the husband, I think, asked Mom something along the lines of, if I ordered you back, what would you do? And I think Mom made the statement, probably to what Your Honor is referring to, I'm the primary parent or something like that, and I guess I would have to go back.
So how is this a geographic restriction? When you look at the trial court's order, the court imposed a time-sharing schedule assuming the wife was moving back to Brevard and kind of establishing a different time-sharing plan if she decided to stay in Orlando. The trial court didn't require she go anywhere.
Well, the mom testified she wanted to stay in College Park. I mean, that was her position during trial. I think what Your Honor, I think, is getting to is when the judge asked the question of, hypothetically, what if I did this, what would you do? Her intentions were very clear that she wanted to stay in College Park. She wanted to continue to be the primary residential parent with Dad having time sharing. So to answer your question, it was a geographic restriction because here's what it was. Mom was in Orange County. Dad was in Brevard County. And the court said, here's what I'm going to say the time sharing is, but Mom, you have to stay in Brevard. So if Mom moved out of Brevard or did not move back to Brevard, then her time sharing was not just modified, it was completely altered. The judge completely changed it. So that's, in fact, exactly what the court did.
Well, how did the court, and this is an original action, right?
Yes, sir.
There's no modification, there's no requirement of substantial change in circumstance.
Correct.
So the litmus test is what's in the best interest of the child.
Correct.
And you agreed with me as far as the judge's determination as far as two priorities. So I'm trying to see where the geographic restriction is. It seems to me the judge is saying, you can live in Orange County, that's fine. If you do, then here's what I find is the best interest of the child. Or you can live in Brevard County, that's fine. And if you do, this is what I find is in the best interest of the child as far as time sharing.
Well, but the court initially, after going through the findings, and found that the child should be residing primarily with Mom. And so on the hierarchy, as Your Honor put it, the first tier, the judge said, okay, I've heard everything. I think Dad should certainly have time with the child, but I believe that the primary time-sharing parent should be Mom. And so what the court did is condition that, what it found is its initial priority, conditioned upon Mom staying within a county. And there's a case out of the 3rd DCA from a couple years ago. It was a relocation case, and Mom was in Miami-Dade County, and Mom wanted to relocate to, I think it was Palm Beach County. And the court denied the relocation, but said, not only are we denying the relocation, but you have to stay within Miami-Dade County, which is in essence what this court did, the trial court did in this case, is saying you got to stay in Brevard County. If you move from Brevard County, you're no longer the primary time-sharing parent. And the 3rd DCA in the Namey versus Corzo case said, any geographic restriction is contrary to the dictates of the relocation law 61.13001. So the legislature determined this is how we're dealing with these geographic relocation situations, and to impose a stricter requirement is contrary to the plain language of the statute. And
there's one of the things that I hear you say, and I read here, was you've got to stay, according to what you just cited, the DCA opinion there. Here it was a directive, the child must be brought back to Brevard County and the mother may move, not you must move. So she did have options, did she not?
Well, of course, but ordering a child back, you can't just, in essence, order a child back. Child can't pick up and sort of relocate. Child's hooked to one of its parents. And
The child was spent 7 years in Brevard and 2 years in Orange. So it spent more of its life in Brevard County.
That's
And was
accurate.
going back to presumably reside with him or with her if she chose to move back, her choice, right?
Yeah, that's correct. But I think, again, the issue is what the court, when it's dealing with these situations, is it has to take the facts for what it was. And basically, the trial court's primary sort of thing that it kind of hung its hat on was the dad having meaningful relationship with the child, which is really, like I said, is the policy sort of in this state. And so I think what we'd be doing in this case by affirming this is sort of setting up a precedent that every time a judge has dealt with a situation where parents are far apart, it's always in the best interest of the child to have a meaningful relationship. So does that mean if mom had moved to New York, 6 months or a year before, or mom moved to California and established herself, sort of like what this mother had done, this was not a mother who just tried to abscond from the venue of this court. Is a court going to say, well, dad was in Florida, mom's in New York, we all agree it's the policy of the state of Florida for dad to have a meaningful relationship. Mom, we force you to move back. And if you don't move back, then we're gonna in essence penalize you. And that's what the court did. And so, that's sort of our position on the first point. We also think the fact, the dad did not plead for the relief that he sought. His pleading specifically asked for 50-50 or an equal time sharing arrangement. That's an issue, and that the specific, what the trial court did was not pled by the dad in his pleadings. Their assertion is that, well, it was in the pretrial statement. That doesn't get around, obviously, the immense case law that says you have to have appropriate pleadings. But the pretrial statement in this case, all it asked for was, again, an order back to Brevard County and a 50-50. So even if the court was to take dad's position that, okay, the pretrial statement for some reason supersedes or overrides the dad's original petition, it's not even what he pled for or asked for in the pretrial statement. So the relief that was granted ultimately to dad was not appropriately pled for, and obviously due process requires appropriate pleadings. Our third point on appeal here was really one of the key issues in the case was the issue of the homeschooling. And basically what had happened prior to trial, about a year or so before the parties went before the trial court, the court entered an order appointing an educational evaluator, Dr. Catherine Mendoza. Dr. Catherine Mendoza tested the child. She interviewed the child and spent several hours with him on a couple different occasions. She interviewed mom and dad. She interviewed the school records, homeschooling records, and all that sort of stuff of the child. And then she ultimately opined that homeschooling was in the best interest of the child. Not only was homeschooling in the best interest of the child, but the child would also need some issues regarding auditory training and assistance. He had some significant auditory issues. She also recommended dyslexia remediation, and that was a stipulated expert that both parties stipulated to, and there really wasn't any evidence to the contrary. The father testified his son had a reading problem. That was about the extent of his testimony on that issue, and obviously the child had a reading problem. Dad had testified.
There was testimony that the child was behind normal benchmarks in, 5 out of 7 subjects?
That's absolutely
And
correct.
considerably behind. So that would be evidence, right?
That was evidence offered by the expert, and in fact, the expert's the one who made those findings, and the expert actually specifically said that it wasn't the homeschooling that was failing with the child. It's just that unfortunately, this young boy had some significant defects, mostly related to auditory issues, processing speed, had sort of some special needs in a way, and those issues needed to be addressed. She actually, in fact, said that the services that he would get within a homeschooling environment would actually be ones that he could not get in a public or private school environment. So the unequivocal testimony of the expert was she felt homeschooling was in the best interest, and she in fact said if the child was in regular public school, he'd probably be doing worse.
Yeah, by definition, homeschooling, there's some individual homeschooling the child, right?
In this case, mom would be, I guess, would be the primary sort of.
So whether homeschooling is beneficial or not can also be largely dependent on who's doing the homeschooling, right?
To some extent, and in this case, the child not only had the help of mom, but he also was in a number of different programs. Like I talked about earlier, the program on Tuesday and Thursday. So it was, I think the parties described it as sort of unschooling, I think was the word that.
But if the judge determined, based on having heard the mother's testimony, observing her, et cetera, that she would, and looking at the test score results, that she would not be the optimal person to homeschool the child, I mean, is that fair for the judge to consider? Not a test of whether homeschooling is better than traditional schooling or not, but whether this person homeschooling is better than traditional schooling or not.
I think Your Honor brings up a great point. I think the court could absolutely say, look, homeschooling in and of itself is a great format, but under these circumstances, it's not. But that's not the findings of the trial court. The findings of the trial court was that homeschooling was not working and the child was not doing well. The homeschooling, the decision by the trial court was not predicated on what Your Honor suggests that, hey, mom may not be the best person to sort of lead the train. In this case, the court found, and these were the exact findings of the trial court, that the court found there was no organic reason why this child was not doing well.
One of the things that I noticed was that the mother had been involved in 4 to 5 different homeschools in the Central Florida area, and Dr. Mendoza was employed and evaluated in this case, but she didn't really seem to have any familiarity with at least 2 of those 4 or 5 programs, except what she learned from the mother. So she opined ultimately that homeschooling was not inappropriate, or maybe it was appropriate, but she really didn't seem to have a lot of information or any information about the 2 actual programs that the child had participated in. Am I right?
She had not known about those specific school or programs. Your Honor is absolutely correct. But I think the record reflected that she did some research and looked into those programs.
I thought the record was that she got the information from the wife.
She got information from the wife as far as the child's academic history and the different programs like you're talking about. But I remember, I don't remember exactly the page, but my recollection was that Dr. Mendoza was unfamiliar with Central Florida Homeschool Academy. But I think she said that she indicated that she had looked it up and researched into, what they offer.
You're down to just under 5 minutes.
If I could reserve my time for the rebuttal now, Your Honors.
All right, thank you.
Good morning. I'm Michael Poe, and this is Darren Meacham, co-counsel from Brevard County. We have a disagreement, actually. I mean, the fact is that there were a number of things that happened here. Dr. Harrison, as soon as, and I think it's I know it's in the final judgment, the filing was the day that they separated. So they had that house in Orange County, but that was an investment property, and so that they could see how that school over there would help this child who had never really been in school before, just not even finished kindergarten. The wife didn't want him in school. He wasn't getting enough exercise and everything else, so she wanted to take care of him. He agreed we would try that as an experiment. Obviously, that didn't work. The child never progressed, was very bad in reading. That's why we filed a motion to have him tested, because the doctor kept saying, he can't read. He's 8 years old and he can't read. We looked at the test and that's exactly what it said. He was reading as a 5-year-old, and this was after 20 months of being with the mother, with her homeschooling him. When they separated, again, I'm not sure about exactly how to read that statute on relocation, but it says when the petition is filed. The petition was filed the same day that they separated, is what the court found. So in accordance with that, she should have then filed something saying, I want to relocate. That never happened. We had 2 motions to bring the child back to Brevard County, but because of his being in the reserves, he was deployed both of those times and we couldn't get him heard. So we never did get in front of the judge about having the child returned. That was always right there out in the open. Everybody knew that's what we were doing. It's in the pretrial that's exactly what we're doing. And the case law says if it's in the pretrial and they don't object, then, and they try the case, then they've had notice. And as a matter of fact, the attorney for the the trial attorney specifically asked her, he said, you understand that what we're here to find out about is the child going back to Orlando, to Brevard County? And she said, yes. I am the one that asked her, Ms. Harrison, if the court orders the child back to Brevard County, will you go? She said, yes, I would go because I'm the primary caregiver.
Well, is this in effect a geographic restriction when the court imposes a time-sharing agreement that the wife can live with if she's in Brevard, but is so unpalatable that she really has no choice but to
I really don't think it is, because he's not telling her what to do at all. He's just saying, this is in the child's best interest should she come back to Brevard County. Because the doctor said, initially in the pleadings we said 50-50, and then he said, well, maybe the schedule would be better if it was 6-8. I get 6 days, she gets 8 every 2 weeks. And the court said, yes, I'm going to go ahead with that, and that's in the child's best interest should she come back to Brevard County. But if you don't, then we have to come up with another plan, and that'll be long distance, and that's what he did. She said, I'm not coming back. So the court said, okay. You don't have to come back. We're not restricting her. She can move wherever she wants. But the court certainly has the right to have the child come back to Brevard County. What counsel was saying was, what if somebody moves and they're up in New York for 6 months? Or, that's a different case entirely. They're already gone. This one, if we follow what he's saying, if somebody decides, okay, I'm going to get a divorce, I'm going to take these kids and I'm going to leave to Tallahassee right now, and then the husband or the wife files for divorce, that means the court can't make the child come back? That's what they're suggesting, and that's never been the case in Florida. The first thing the court looks at is what's in the child's best interest, and the court made it very clear what's not only in the child's best interest, but what she was doing was detrimental to the relationship between the child and the husband. That was brought out by the court on numerous occasions that what she was doing was detrimental. Not just that it's in the child's best interest, but it was detrimental as well, because she would not let him spend overnights with the child for 2 years. He didn't get to have the child overnight. And her opinion when asked, what should the court do? What do you think should be the time sharing? The same thing it has been on the past 2 years. She said he can see him when he wants, but she'd never let him before that. She kept saying, I want to see him, and he never got to see the child. So all of that is being taken into consideration when the court is making a determination that this child has to be back here in Brevard County with the father so he can have a relationship. And it wasn't like she's got a job sitting over there in Orlando and she can't leave her job or she'd lose her job. All of her work was on an internet. So she could do that from anywhere. She just didn't want to be in the same area with the husband and the husband have any type of relationship with this child. And that's what had happened for 2 years, the entire time that they were separated. So for the court to turn around and say, listen, it's your option. You can have I think it's best if you're all over here and you can have the majority. If not, then the child still stays here because he's going to take care of the schooling because the two of you have disagreed on that completely, and somebody has to make a decision. And the court specifically said, if this was a post-divorce action and you had a disagreement as to homeschooling or regular school, you have to come in and ask me to make a decision. You've already done that. You're doing that right now, and I'm saying that it's in the child's best interest because of how poorly he did in homeschooling. And what the judge said about that was that he thought homeschooling was very good. He wasn't saying homeschooling is a bad thing. But he said this was a plan it was an experiment that didn't work. And that's what what the doctor was saying entirely. He said, I wanted to try it to see if it would help. My biggest concern is his education, and he's not getting an education. She's traveled all over the country with him, doing this and that, costing a lot of money, $2,500 a month for homeschooling, because she's taking him all over the place, getting him involved in everything in the world, and he's paying that. But that had nothing to do with the fact that the child was just not doing well at all. And certainly, she never had the child tested again after the first test, which was, 2 years later, when the expert testified, the child was not tested again. They went in and said, listen, this shows that the child's doing well. We're saying, it shows that the child is doing terrible. And that's what the court found, that this child was not doing well at all in the home school environment. And the judge ordered, and my client agreed I will take care of any costs associated with him tutoring, anything else going on, if this child comes over here and goes to school. And so that's been happening now for about a year or so. But in any case, the court made all of those findings based on the testimony of the parties. And it certainly isn't an abuse of discretion. It's certainly not an abuse of discretion to have this child come back, because it's not telling her she has to relocate at all. The case that he was talking about was a geographic restriction, but that was a post-divorce, a modification, and then they put a restriction on it. On this case, all he said was, you can live where you want, the child's coming back here. You only live 76 miles away, but we can't have you going back and forth to school in Brevard and over there. So this is where it's going to happen. And then, I don't know if did I miss anything let's see. Any other issues that you're concerned about? Do you have any questions about anything?
What's your response to the argument that your client didn't plead for majority time sharing?
Well, what he did, we pled for 50-50. That was in the initial pleadings, and I was looking because normally I put in, unless the court deems it not appropriate, and then we should get a majority. I don't know if I put that in the petition or not, because I don't have the petition in front of me. But the fact is that she was given 50-50, more than 50-50, should she just come to Brevard County, where the child should be. The only reason he got more was because she decided, I'm not coming. So is he supposed to turn around and say, okay, now I find it's not in the child's best interest to be with the father, even though it's detrimental and everything else
Was there an objection below to the alleged pleading deficiency?
No, sir.
Okay. So
There was no objection whatsoever. Everybody knew from the very beginning that that's what we were doing. It was in the pretrial. They didn't make any objection whatsoever. It was tried by consent then. And so the court then could do what it needed to do, because there was absolutely no objection to any of the things that went on in that trial.
Okay. Any other questions? All right. Thank you.
Thank you, Your Honor.
Same question I had for Mr. Poe. Was there any objection to any alleged pleading deficiency below?
I believe, yes, there was, and there was a motion for rehearing filed, and I believe that issue was addressed in a motion for rehearing that was filed after trial.
Okay,
So
but
during
prior to the motion for rehearing?
Well, I don't think, the pleading and the pretrial statement both asked for 50-50. So I think it was reasonable for mom to think that when they went to trial, that was what dad was pleading for. The judge then, after the trial, in his final judgment, then does this, okay, the child or whatever is going to move back to Brevard, and then dad's going to get majority if not. So that was never requested by the dad at trial. Dad specifically said at trial he wanted 50.
Well, there are kind of two orders here. One was the order that said, assume that the mother would come back, and then the second was the order that was entered after she didn't come back. So was the motion for a hearing that you're referencing, was that to the first order or the second order?
That was that was in between the first and the second.
Okay.
That was in between the first and the second. And so I just want to make a few points clear, if I may, quickly, Your Honors. There was not a finding by the court that they separated on the day of filing. The evidence and the finding from the court was that mom had moved to College Park prior to filing, and it was a move that was agreed to and facilitated by the father. So that's a distinction, I think, that needs to be made aware. The second
Let me ask you, going back to the pleading, the pretrial statement, did they say if the mother doesn't come back, we want majority time sharing?
No, what the pretrial statement said, father's pretrial statement was they want the child returned to Brevard and they want 50-50. That was it. There was no further elaboration. It was basically 2 lines. So that the pretrial argument of, doesn't really hold any weight in this case. Counsel, again, was talking about the issue of if somebody had moved to New York, the example that I had given, that's an issue, I believe, for the legislature to perhaps fix or modify or add to the statute. The statute is very clear. There's a whole bunch of cases that say, the courts do not have the authority to extend, modify, alter 61.13001. So this is the statute we have, and in this case, the court, in essence, restricted that and said, Mom, you have to stay in Brevard County, and if you don't, then we're going to do this, we're going to take the same remedies as if you did violate the statute. And so while I wouldn't condone somebody taking off for New York or taking off somewhere and trying to kind of beat the system per se, that's not what happened in this case. But I think that's an issue for perhaps the legislature to deal with, and perhaps put an exception that if maybe alter the date or give the court some discretion on that date. There's actually a case that I cited that talked about how the filing date is the date. So if a person I think it's the Rawlison case, if a person relocated 1 day before the filing, then theoretically they've beaten the system. I guess I hate to be so, but that would be my interpretation of it. I just want to make one last point for your honors, is the second point we really didn't talk about much on appeal, is the court gave dad ultimate parental responsibility, and basically cut off the mom's shared parental responsibility decision-making rights with regard to schooling. The issue was the continuation of homeschooling. The trial court made its decision, albeit we believe an incorrect one, but we don't think that in and of itself was grounds to give dad ultimate parental responsibility. The case law clearly says that in order for there to be ultimate responsibility, there has to be convincing evidence of hostility, and that and that shared parental responsibility is unworkable. These folks, while they fought over the homeschooling, there wasn't a level of conflict like you see in some of the cases I cited in my brief. One of the cases that I cited, I think the Craney case, talked about dad being vulgar and dad insulting mom and really kind of being nasty to her. And the court, even under those circumstances, said there's not evidence to show that there's such a pattern of hostility between the parties that we're going to award ultimate responsibility.
Can the hostility, however, be failure to communicate adequately and resulting in a detriment to the child, i.e. a reading deficiency?
That could certainly be a grounds, but that's not the facts of this case. The reading deficiency that everybody keeps talking about was because the child had issues. Unfortunately, this child had issues, and he had special needs to some extent, and those had to be addressed. So it's not as if the homeschooling was failing him, because Dr. Mendoza felt otherwise. Thank you, Your Honors.
Thank you. All right, thank you both, and we'll move on to the next case of